I'm Spencer Muzik, and joining me now is John O'Malley. He's a partner at Fulbright who represents Richard Suen, a Hong Kong businessman who was recently awarded more than $100 million in his lawsuit against casino operator Las Vegas Sands Corporation. Welcome, John. Thank you for joining us today.
Thank you.
So, John, the main question here was, did your client play a critical role as the middleman in helping the Sands win and secure its gaming license in Macau, China? Is that right?
Yes, we think Richard Suen and his company Round Square provided a great service to the Sands in helping them get the license back in 2001. The Sands had to jump through a lot of hurdles in order to get that license, and Richard Suen was there through many steps of that after organizing very significant meetings with Chinese government leaders in the summer of 2001 that ultimately led to the process that got the Sands their subconcession in 2002.
And wasn't he also the one to tell Adelson, who's the chairman and CEO of the Sands, about this venture out in Macau, China? The opportunity, anyway.
That's correct. Sheldon Adelson admitted at trial and in prior depositions that he had had no prior knowledge of any possibilities in Macau. As you know, at that time, the Sands had the Venetian property in Las Vegas, but it did not have any properties in China or in any part of Asia, for that matter. So Richard Suen was the person who introduced Sheldon Adelson to the possibility of gaming in Macau.
And so the casino operator didn't deny that there was a success fee in place here, but it says that Suen is owed nothing because he didn't hand deliver the license and that the Sands won it through a competitive process. So was there a written contract here, and what were the terms for the success fee?
Well, we argued two things at trial. One was that we believe there was a written contract through an exchange of faxes between our client, Mr. Suen, and the Sands, particularly its former COO, Bill Widener. The jury ultimately decided that there was not a contract in place between the parties, but that Mr. Suen, and particularly his company, Round Square, had performed valuable services for the Sands. But yes, we believe there was a contract in place. And that the exchange of faxes clearly provided that there would be a method of payment of Round Square and Mr. Suen of $5 million plus 2% of the net profits to be derived from the results of the gaming license. That, of course, led us to seek the amount of that formula as it's presently calculated.
Well, in that trial, in your closing arguments, you compared your client to a real estate agent selling a home. Can you explain that analogy?
Sure. Basically, the Sands' defense was, well, wait a minute. Mr. Suen, you didn't help us. We helped ourselves. We're the ones that sold our business to the Chinese and Macanese government, in essence, by saying what a great job we've done in Las Vegas, and we can do the same job for you. That was a very similar argument that a home seller might make to his broker when his broker comes asking for a fee, to say, well, really, the house sold itself. You didn't do very much. And the point of the argument was simply to show that people who are in the process, who help the sale along, or who help the effort to get the license, deserve to be compensated for their services. And we believe that Mr. Suen should be compensated, his company should be compensated in the manner that the parties had agreed.
Well, and it was obviously persuasive. So what was the breakdown of the total award here, which I believe was $101.6 million, actually?
That's correct. That's the current value of the judgment as entered by the court. And the breakdown is like this. Mr. Suen's company, Round Square, was awarded $70 million by the jury. Now, that was based on the jury's conclusion that that was the value of the services that Round Square, through Mr. Suen and his colleagues, had provided to the Sands, worth $70 million. Because the case was filed back in 2004, and under Nevada law, the calculation of interest depends on the filing date of the complaint, that an interest factor was used, and the current interest factor is 5.25%, simple interest from October of 2004. So that's how we get to the $101.6 million, which is the amount of the judgment today.
And so this is the second trial and the second win for the Hong Kong businessman on this issue. But well, so how much was he awarded after the first trial?
The first jury back in 2008, so about 5 years ago, came up with a verdict of $43.8 million. There was a substantial amount of interest added to that, and the judgment was, I think, around $58 million, which then, of course, grew during the course of the appeal. As you're aware, the Nevada Supreme Court reversed that first judgment and sent this case back for retrial, which is what we recently completed. So, as you can see, the value of the award increased substantially between the two trials.
Yeah, and the jurors knew nothing about the first trial, is that right?
That's correct. Both parties agreed, and the court agreed, that it would be a mistake to tell the jurors that there was a first trial or the outcome of that first trial, because that might influence their decision here. Now, the jurors saw testimony from the first trial. It was videotaped, so they saw witnesses testifying in a courtroom and being asked questions in a courtroom. They even saw a picture of the first judge a couple of times. So I imagine some of the jurors
they had to know.
Guessed.
They had to know.
They
had to figure it
probably
out.
guessed.
Well, after 9 years, though, of litigating this matter, it might not be over just yet. Isn't the Sands planning to appeal this latest decision?
That's correct. And where we are right now is the Sands have filed post-trial motions, which will be heard on July 30th. They're attempting to get a new trial or to knock out the case entirely. And the judge will have to rule on that. That'll go to the trial judge who recently tried this case. Then the Sands, if they are unsuccessful, vow an appeal to the Nevada Supreme Court, which we will, of course, participate in, and will defend the judgment if the Sands elects to appeal. What's
the basis for the appeal now?
Well, we don't know exactly. Of course, the Sands opening brief on the appeal won't be due for quite some time. We can anticipate the Sands is going to raise a lot of the arguments that it raised in the trial court so far, and the arguments that it's raising in the post-trial motions. Essentially, the Sands is raising evidentiary concerns, certain technical legal arguments involving standing, and a couple of other arguments. They claim the damages are too high, and a few other things. Most of these arguments are really factual arguments based on the weight of the evidence, and traditionally courts defer to jury decisions on determining the strength of the evidence. So we, of course, will be arguing that the jury verdict should be upheld because the jurors had all the evidence. They looked at it carefully, they weighed it, and they made a decision.
So, John, tell me this. Why do you think a company that has been incredibly successful in this market would spend the time and resources on a third trial over relatively a minor sum as compared to its earnings?
That's a great question, and it's one that should be posed to Sheldon Adelson. We believe that that Mr. Adelson should have made good on this obligation many, many, many years ago. And in fact, what came out in this trial and in the first trial is that Mr. Adelson actually proposed an alternative payment scheme to Richard Suen while the parties were still friendly with each other, before any litigation had even been threatened, much less commenced. And Mr. Adelson valued that offer in testimony that was played to the jury, and that valuation was in the neighborhood of $100 million or more. So we think that the jury this time, like before, got it right. They considered the offer that Mr. Adelson had made, the proposal he'd made to alternatively pay Mr. Suen in a different structure, and that was worth a substantial amount of money. Very similar, by the way, almost identical to the amount of money that will ultimately be paid under the judgment if it's enforced.
Is this a case of a friendship gone sour?
Oh, I think it might be. Look, my client had a lot of respect and affection for Mr. Adelson. They worked very closely together. As I think you probably know, my client was friendly with Mr. Adelson's brother for a number of years before he even met Mr. Adelson. And I think Mr. Adelson had a great deal of respect at one point, probably not so much today, but at one point for Mr. Suen and his capabilities. So I think they were on very friendly terms. Some of that came out at trial. It was quite clear that they had a certain amount of affection for each other. So I think that there is this idea that the relationship soured, but it soured as a result of non-payment of an obligation, and that's at some point Mr. Suen felt he had to assert his claims because there was simply no other way he would ever get paid.
Well, we will certainly stay tuned to see whether or not there is a new trial in this case, but thank you so much for joining us today to talk about it.
Certainly, it's my pleasure.
For more information on this or other topics, subscribe to BloombergLaw.com. You can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.